Hello, everybody. You know what? We're not doing the usual countdown today because I completely forgot to do the countdown today. So that's on me.
Boy, we're not starting things off right.
I know. So now we have to wait an extra like 30 seconds for people to tune in because you guys don't get notifications.
Now I
that
can
we're
operate
live.
like this. I'm conditioned. You hear that do 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 do
Here,
do.
you want to
No
hear
no
it?
no no no. No, we don't.
Like
We
that?
don't. Yeah. Okay. I'm
No?
good. Now see now I'm good.
Oh, okay. Oh, someone's here. Aaron. Awesome. Okay. Yes, we're here. We're here, Aaron.
Wait, is that plugged into the computer?
This is plugged into the computer, I believe. Wait, what's this?
Because I shouldn't be able to move my mouse if that's connected.
No, it's fine. It's plugged in. Remember, we changed the plug for your keyboard, not the mouse. The mouse is fine. It's all good.
Okay.
Yeah, we're all set. Technically, we're good. Everyone, we're good. So we have a special guest with us today. So we are going to get started here.
Okay.
Are you reading
I'm reading
comments?
Aaron's, waiting for him to be snarky again.
Yes. Okay.
See, he was counting on us. Now we're counting on him.
Yeah. Let's see. It's 5:03.
Oh,
okay.
okay.
Here we go. All right. So we are recording here. We're going to record this here. And Richard, do your
All right.
claps.
Levels good?
Well, try.
Levels good. Levels good. Levels
Announce
good.
to them.
Levels good. Levels
Yes,
good.
levels are good. Levels are good.
All right. And here we go. On January the 1st, 2024, thousands of copyrighted works from 1928 entered public domain. This was the day Disney has been dreading since the shorts Plain Crazy and Steamboat Willie, both featuring Mickey and Minnie Mouse, crossed over into the domain of the public.
Other notable public domain entries include J.M. Barrie's original story of Peter Pan and House at Pooh Corner, which introduced Tigger. So here with us now to discuss all the legalities of public domain is B.J. Priester, a law professor at St. Thomas University College of Law.
Hey, BJ!
Hey, Richard and Sarah. I'm excited to be here and talk some law.
Well, we are so happy you can join us for this particular discussion since you are a law professor and a big Disney fan.
Yeah. As judging by your shirt right now.
Now, tell us about your background in law and how long have you been teaching law?
So I have been a lawyer for 25 years, and I've been a law professor about 20 years. And I teach mostly in criminal law, but I do teach some constitutional law, which includes First Amendment. And there are some First Amendment free speech issues that come into play with copyright, right? Anytime you stop other people from speaking, that has First Amendment issues in it. But when I was a lawyer, part of what I did back when I worked at a law firm in Washington, D.C., one of the partners that I did a lot of work for was an intellectual property lawyer. And so I did a lot of trademark, in particular, litigation with him. We represented some wineries out in California, dealing with lawsuits about different wineries using different words like Napa on their wine labels and who can and who can't, and you can sue each other over it. And represent other clients as well, and filed for injunctions and all sorts of fun things like that. So I got to do a little bit of trademark mostly in terms of intellectual property when I was a practicing lawyer years back. And I have kept up on it. As Richard said, I'm a Disney fan. I'm a Star Wars fan. I blog, I podcast, mostly about Star Wars, some about MCU and other things, and sort of made my way into the fan community through fan fiction. So as a lawyer, when I started writing fanfic, I said, I might want to figure out whether I'm going to get sued for this or not. So I did a little, back in the day, and have kept up on it, also the copyright side of things. And so copyright comes up a lot with any fan works. I mean, fan fiction, fan films, fan art, even cosplay, costume designs can be copyrighted. So there's a lot of copyright, and fair use is a doctrine in copyright as well. So I sort of have followed the intellectual property side of it in the last 20 years, mostly through the fan side, through the things I'm interested in fandom and following Disney and Star Wars and how they use their intellectual property rights. So I think, it's really interesting to see now that this is the first sort of major pop culture event in our area of fandom, Disney, Star Wars, Marvel, to come into the public domain and what the ramifications of that will be.
Yeah, in a few years, Pluto will be entering the public domain, and a few years after
Probably
that,
Donald
Donald
Duck.
and Daisy.
Right.
So
And it's interesting
Disney
what,
lawyers settle in.
yeah, and it's interesting what different properties will allow of their copyright. Like Disney doesn't, or Star Wars in particular, doesn't seem to care whether fans use their products in things like podcasts or what is it, cosplay, things like that.
Because it's helping them. It's free
Yes,
marketing.
it's
As
free
long as we're
marketing.
not making like millions of dollars, they're okay with it because we're on their side.
Right.
Whereas before, Paramount Pictures would come in, oh, you're using Star Trek, and they would start slamming these fans. Like, wait a minute, we're making fan films.
Right.
And then when the fans spoke up, the Paramount said, oh, we're going to go with what Lucasfilm was doing and letting fans make their fan films.
Yeah, I mean, Harry Potter in particular isn't very like friendly to fans. Like I was in a thing where I did Professor McGonagall for this like podcast where we read the book kind of as a play. And like after we aired the first episode, they were like, shut it down. So they shut us down. And like as fans, we couldn't participate at that anymore.
BJ,
yes,
the property owners, they've got to protect their properties or everyone would be doing it. And then it could enter public domain a little quicker. I know there's a better way of saying that, but if they don't protect their property, then they could lose the rights, right?
So as always with the law, there's always technicalities to it. But you're right. The short version is if you're a copyright owner or a trademark owner and you don't police other people infringing your rights, you can either sometimes forfeit the rights entirely, or maybe not technically forfeit the rights, but kind of lose the ability to enforce against other people, right? So if there's a fan, just like Sarah was saying, so if there's a fan podcast that reads a book and you don't do anything, and then another fan podcast does it, and another fan podcast does it, and then you try to sue the fourth person,
right?
And you're like, oh, there's too much of this is happening. And you now try to sue the fourth person. The fourth person is going to come in and say, but wait a second, you knew about these other three and you didn't sue them. So how can you then turn around and sue me? And the rights owner might lose for that reason. The court might say, well, if you haven't been rigorously enforcing your rights, at least as to this, we're not going to let you do it. And that's one of the things that's tricky too, right? Is a lot of these rights come up in different ways. And so, you might say, oh, well, we're not going to go after the fan cosplayers. But if somebody were to try to, like with the 501st, I'm going to sell Stormtrooper outfit. Right. And I'm going to make a profit by saying, you send me your measurements and I'll build you a Stormtrooper costume. And I'm going to make whatever 100% markup on my cost of materials and labor to do that.
Right.
That's not necessarily a forfeiture problem if they say, well, we're only going to sue the for-profit fans, not the nonprofit fans or something like that. Because the court would say, well, that's different, right? That's a different use of your rights.
Right.
Yeah. There's a couple of comments here about official fan fiction in the Sky Chat. Yeah, official fan fiction is The Force Awakens.
The Last Jedi. Yeah.
Well, no, because J.J. Abrams is a big Star Wars fan.
Right.
And so as a fan, he's writing Star Wars. So in a way, that could be official fan fiction.
And some of these rights owners, and most of them don't, but some of them do, you can basically authorize fan works to be not necessarily, whether they're canon or not canon, I don't mean canon or not canon, but you can submit fan works or publish your fan works and we won't sue you. And Lucasfilm did this at one point with fan films, where there was an official fan film contest through StarWars.com. And of course you had to assign the copyright to Lucasfilm. You basically gave up your own rights, but it was a fan film contest sponsored by Lucasfilm that people could enter, and somebody won. right? And I think they
Mhm.
did it at Celebration or something like that, didn't they?
Yeah. Oh, yeah. At many
You know,
celebrations,
so
they had the fan film awards
And San
yes.
Diego Comic
and
Con, I
Comic Con. That's,
believe.
that's where it started at
Yeah,
Comic Con.
San Diego Comic Con.
So you could do, and as a rights holder, you could choose to do that. You could say we're going to have a fanfic contest or fan art contest.
Right.
But you would be putting parameters on it, right? You'd be saying,
Right.
for example, like you can enter this contest and we'll agree not to sue you, but you'll also agree not to sue us. Or
Yeah.
you have to give us a license to, if we really like your art, we can sell t-shirts with the art,
Oh,
right? Instead of you selling t-shirts with your art. And things like
yeah.
that, right? So that's where a lot of people don't necessarily want to agree to the terms of the
Oh, no.
contest, right?
No.
So, but that, I mean, you could do that. I mean, but again, it's up to the rights holder, right? It's up to the person. If they own the copyright, they can say, I'm not going to have any official fan works that I'm going to recognize. They just say, like, if you want to go on Archive of Our Own and post your fan fiction, I know it's there, but I'm not going to read any of it. And you're not making a profit on it because it's free online. I'll look the other way. Fine. And that's, a lot of most franchises do that.
And that's why a lot of fan films will say a fan film, or podcast will say a fan podcast.
Right. In fact, we are required to say
Yes.
fan podcast at the end of our podcast.
Just so no one will confuse us with a Disney affiliation.
Official.
Yes.
A Disney affiliation.
Yeah.
And that's, that's really the main difference between copyright and trademark. Right?
Oh.
Because you actually do own the copyright in all of your Skywalking Through Neverland podcasts. Because you record them, it's your work, it's your words, and you own the copyright in your video file, in your audio file, in a written transcript of your file. And nobody can Lucasfilm can't stop you from recording a podcast about Star Wars, because whatever you say is your own. However, Lucasfilm or Disney has trademarks in terms like Star Wars and Luke Skywalker and lightsaber and things like that. So it's actually the trademark side of it where they say, we want you to, and Disney has a bunch too. We want you, if you're going to be a fan podcast, we might someday, as the brand, we might have an official podcast. Marvel Comics has an official podcast, right? And so they say, well, we don't want there to be confusion in the audience, in the market, of what the source of this is. So we want people, if they want to find an official Star Wars podcast, they know where to look. They can find it. And if they find fan podcast, it's clear, oh, this is unofficial. This is unauthorized. I love that. The unauthorized parody, right? The unauthorized story. Then people know, oh, well, I'm not getting an official analysis of a Disney movie or a Star Wars. I'm getting something from the fans. And then they can't sue you, right? Because they know, because you've now made clear, I don't claim to own Star Wars, and I don't claim to be an official Star Wars piece of work.
Now, when it comes to, like you were saying, trademark and copyright is the characters and the ideas, whereas trademark is more of the logo and the name. Is that correct?
That's roughly right. So copyright is your rights in what we call authorship or expression. So copyright is your rights in, and you can, again, written copyright is where it starts, obviously, but you can copyright This is why there's Taylor's version, right?
Okay.
Because somebody owns the copyright, whoever the bad guy whose name I forget, right? The old manager. He owns the copyright of the masters in the original recordings. But she owns the copyright in the song. She owns the copyright to the music and the lyrics, but he owns the master. So when Taylor Swift re-records her entire catalog, she now owns the copyright, not just in the music and the lyrics, but in the new masters. And she has enough sway in the marketplace to convince everybody, please don't buy the recording from the old masters anymore, buy the recording from the new masters. And she's not infringing the copyright in the other guy because it's a different sound recording.
Right.
And he's not, and if he continues to sell her old masters, he's not infringing her copyrights because she assigned him a license, right? When, he doesn't own the actual song.
Correct.
He owns the recording.
Okay.
So anyway, so copyright is your ownership in your expression. So actually, Richard, you say it's sort of funny. you can't copyright ideas. So in the sense that you can't copyright an anthropomorphic rabbit police officer, right?
Huh.
That's an idea, but you can copyright Judy Hopps.
Right. Yeah. I meant an idea that's been produced,
Right. And
like
so
Judy Hopps.
right. So you can copyright a character, you can copyright a story, and we've heard a lot in the news the last few weeks, plagiarism, right? We think plagiarism is a form of copyright infringement in the sense of you're like verbatim copying, right? You go and you verbatim copy somebody else's words and you republish them without attribution, so people think it's your work. That's a really brazen form of copyright infringement. But you also have stuff like, we see this come up in all sorts of stuff. Bram Stoker writes a vampire book, right? And that's now in the public domain. So then Anne Rice writes her vampire books. And then Stephanie Meyer writes her vampire books. And maybe somebody says, it didn't actually happen this way, but Anne Rice will say, I think your vampire books are too similar to my vampire books. I think they're not plagiarized, right? You didn't use the same characters. You didn't copy the same passages, but you stole my characters. You stole my story, and I'm going to sue you for copyright infringement. And we see this a lot when people try to, as we say, file the serial numbers off their fanfic and republish it as an original story, right? Is you might end up getting sued by the copyright owner of the original thing. So if you write a Star Wars fanfic and then you just say, well, I'm going to call it a laser sword and I'm going to call it Starfighter a different name. I'm going to rename all the characters. So instead of Luke and Han and Leia, it's, Bob and Joe and
Carrie.
Whoever. Carrie. Yeah, right.
Yeah.
Exactly. Mark and Carrie and Harry. Right? Then, they might still be able to sue you because they might say, well, this is an infringement. And so copyright is that. And then trademark is, so it's trademark. We call it a mark. You protect your mark. And the mark can be anything. It can be a word. It can be an image. It can be anything that serves as a mark, as an identifier. And we typically think about it in, as you were saying, as in terms of a brand.
Or
right?
a logo, right?
Or
a logo for a brand.
So Nike has trademarked the name Nike and that swoosh, right? Now, obviously, they can't prevent people from using the word Nike because Nike is a Greek goddess. It's right. But they can prevent other people from selling shoes with the brand, with the name Nike. And they've expanded into athletic wear, right? So if you want to sell, jogging shorts, you can't call them Nike. And we know, my favorite is there's Delta Airlines and there's Delta Faucets, right? So, and they both have a trademark, but neither they have a problem because Delta Faucets doesn't have anything to do with air.
No one's going to confuse one for the other.
No one's going to confuse one for the other. Exactly.
Yeah.
And so
not going to use a faucet to fly to Florida.
Exactly. And so trademarks, and so Lucas, so for example, you can't copyright the idea of a laser sword because that's been around in fiction even before George Lucas. He didn't invent the idea of a laser sword. But Lucasfilm can copyright trademark, lightsaber, especially in conjunction with the Star Wars logo. They can Star Wars lightsaber. They can trademark that. And if you go and try to say, well, I'm going to sell knockoff plastic laser swords and call them lightsabers, they're going to sue you and they're going to win.
Right.
Yeah, like back in the 70s, everyone was making knockoff lightsabers, but they were either calling them light saber, not one word, but two words, or sabers of light. And I doubt Lucasfilm went after any of them just because they knew that to find the person who's doing this is going to take so much more effort than is really needed, and we're not going to do it. And I don't know why they didn't go off and make because Lucasfilm didn't have a mass-produced lightsaber until like 1979 when they had those inflatable lightsabers that no kid wanted.
Right.
They didn't do.
I remember those. Yeah.
So Lucasfilm, but if they can do it, they can get a flashlight handle and a plastic beam. Why can't you do that? But I know that those are cheap, and Lucasfilm, I'm sure we're saying if we're gonna do it, we're gonna do it right. But now titles cannot be trademarked, right?
Well, that's it. That's one of the sort of debatable things, right? Because one of the things that it is with trademark is it's got to be an identifier, right? So if you try to trademark the title of a book, one of the things that you're going to get a lot of pushback on, depending on what your title is, well, this is just generic, right? So if you say, so for example, I feel like, just to use your book, Today in Star Wars History, I don't know if that could be trademarked, right?
Right.
Because that's just a descriptive title for what the contents of the book are, right? Whereas, you push it to something like, Twilight. I mean, come on. There's been books called Twilight before Twilight. There's been books called Twilight after Twilight. I think it'd be more interesting something like The Hunger Games, right? That is a trademark, but it's a trademark for a brand, not just for the title of a book, not just for the title of a movie. It's also the name of the event in the book.
Yeah.
And so, and Hunger Games, that was a phrase that Susan Collins created that didn't exist in that way before. And so something like The Hunger Games, maybe you could successfully trademark. But even then, if you say something like, you publish a academic collection, essays about the Hunger Games, they can't sue you for trademark infringement.
Right.
Because you're not using it.
There's no confusion.
To create confusion. Exactly.
Yeah.
You're just using it as a descriptor for this product. In the same way that we all know this, right? You watch commercials on TV and, Tide runs a commercial and says, we're 3 times better at getting out stains than Glad. And you're like, yeah, you're allowed to name drop the other brand for purposes of comparison in your own advertisement, because you're not creating any confusion about who owns Tide and who owns Glad. You're just wrecking the reference. So, and McDonald's can diss on Burger King if they want or whatever in their commercials.
Right.
And that doesn't create same thing. It doesn't create any confusion because you're not misidentifying what the product is.
Okay, yeah, this was a big thing with Marvel Comics because they were going to lose the name Captain Marvel, but they had to release a comic title, a one-shot, anything every couple of years just to keep that name Captain Marvel
and trademarked in their brand.
Yes, because DC wanted it for their character Shazam, but they were forced to have that character's name changed from Captain Marvel to Shazam.
And that's one of the interesting things, Richard, that you mentioned is copyrights. You don't have a legal obligation to use the copyright. So the big controversy we had a year and a half ago, right? When WB took that Batgirl movie and they just said, we're not going to release it, right? We're going to take a tax write-off and we're going to put it on the shelf and not release it. They don't lose the copyright. They still have the copyright. And if they choose to have a copyrighted work that they own the copyright in, and they say, we are never going to publish this, we're never going to release it, they don't forfeit the copyright. Whereas you do forfeit your trademarks if you don't use them. And that's part of what was going on with that, right? It's like if you trademark something and then you sit on it, it'll expire because you have an obligation. Trademarks only protect you to the extent you're using a logo or a name as a brand identifier.
Right.
If you're not using it as a brand identifier, then you don't get to monopolize the use of that mark.
Because anyone could just sit on all these names, have a whole bunch, a whole bag of names. Like, okay, I have these. I'm never going to use them, but I know everyone else. It's like people who buy those domain names.
Right.
Like someone could go, oh, I want to get Disney.com and buy that before Disney does. Something that they know people will, and it has happened where someone needs that name and they'll pay someone $5,000 to buy their own name to use for a website.
Mm-hmm.
Yep.
Movies do that too. Well, this gets into the copyright part of the law because copyrights do eventually expire, but it's after a long, long time. So should we get into the rules of copyrights?
Sure. You want to?
Yeah.
Yeah.
Going back to 1719, was it?
1710. Yes. So
Oh my
so
gosh.
the first copyright was out. Well, obviously that's before there's a United States of America, right? That's Great Britain. 1710 was the first copyright statute, and it's funny because that comes up with the printing press, right?
Oh.
This didn't really become
Oh
an
my gosh.
issue. Copyrights didn't really become an issue until you had mass-produced books. Because
Wow.
prior to that, what monk is gonna like sit and right? It's Spaceship Earth, right? Like there's no monk sitting in a monastery, like copying someone's whole book, stealing it. Like, come on. So it's mass produced. Mass produced literature is where the problem comes up. And so yeah, this original statute, the original, interestingly for our purposes, the 1710 statute in Britain, copyright was 28 years.
Yeah.
Right.
Wow. Wow.
Right.
Interesting.
So if we stuck with that, Star Wars would already be in the public domain.
Ugh.
Whoa.
Right. Crazy. And then there's a provision in the US Constitution that empowers the federal US Congress to create copyrights in America. So copyright is a federal law domain, not state law, because of that. And then there's been a whole series of evolutions from 1790 and then a couple in the 1800s. And then the main ones that we think about today, obviously, is that there's the Copyright Act of 1909 and then the Copyright Act of 1976. And so, as you can imagine, like Mickey Mouse and actually A New Hope, there's a lot of copyrighted material before 1976.
Yeah.
That's still in circulation and still copyrighted. But everything since an act, even though it's a Copyright Act of 1976, it didn't take effect until January 1st, 1978. So everything since January 1st, 1978 is under this new copyright statute. So anyway, yeah, it goes way back, and part of what's been controversial, and Disney's been an instigator for this, is extending the copyright terms.
Right.
So when A New Hope was released, its copyright would have lasted 56 years, which means it would be in the public domain in 2033. We'd be 10 years away.
Around the corner.
Yeah, we'd be 10 years away from anyone in the world being able to write their own Star Wars work. Star Wars. Now, that's Star Wars. That's not Empire Strikes Back, and it's not Return of the Jedi, and Leia is not Luke's sister, and right. So like, there's all kinds of legal complexities with that. But then it got extended, and so because it was under the Copyright Act of 1909, it would have been 56 years, which is 2033. The Copyright Act of 1976 automatically gave all those existing copyrights a term of 75 years instead. So that pushed us to 2052. And then in the Sonny Bono Copyright Extension Act in 1998, right after, remember he died in that skiing accident?
Yeah.
And so it was right after he had been pushing for this bill, and it was sort of kind of like after he died and everyone felt bad that they said, oh, we should pass this bill that Sonny wanted. And so that changed it from 75 years to 95 years.
Okay.
Which is why Star Wars will now not go into the public domain until 2072, when I expect I will not be there to
Hey, you never know.
Publish my
You
fan fiction. I
never
mean,
know.
you never know. You never know. I'll be 100-something years old.
But then in 2002, that's what Disney had pushed for another 20 years.
Right, but they lost that, right?
No, they won because it didn't take into effect until a couple of weeks ago. So it was the Mickey Mouse Act, which gave it another 20 yees of copyright protection. So believe me, Disney was in there with their lawyers going, what's another 20 years?
Yeah, and that's the 95 years. So that's right, because Steamboat Willie is 1938.
Yes.
Right. And so 95 years is 2023.
1928.
Sorry, 1928. Right. And so that's 1923. And then it expires on January 1st. Because we're not going to keep public domain always happens on January 1st, right? Because you don't want to worry about, this book was published on October 1st, so it goes in the public domain on October 1st, and this other book was October 3rd, and that's and these stuff 95 years old, we're going to keep track of what day it came out, come on, right? So that's why it's just
Disney is
right, yeah. So that's why January 1st, 2024, it's the 95 years, and that puts Steamboat Willie, and I think, what you say, Plain Crazy?
Plain Crazy.
Yeah.
Into the public domain. But, and that's the way I was, thinking about it to explain it, and we can, hopefully it'll help a little bit, is what that means is Mickey Mouse is now like Snow White. Okay. Disney doesn't own Snow White, right? We had Snow White and the Huntsman with Kristen Stewart a few years ago.
Yes.
Anybody can do a Snow White story because Snow White's in the public domain. And it can be a lot like the original fairy tale, or it can be very different than the original fairy tale. Anybody can write a story about Snow White because Snow White's in the public domain. What can't they do? Sell t-shirts with a Snow White that looks exactly like Disney's movie Snow White, who is trademarked.
Right.
Yeah, that design is trademarked.
Right. The
That
blue
design.
and the yellow and the reds. Like, yeah.
Right. And so you can and so nobody thought Snow White and the Huntsman was a Disney movie.
There was no confusion,
right?
there.
There was no confusion, and they didn't, the clothing didn't look anything alike. I mean, they did have a brunette girl playing the role, I guess, but other than that, I mean, there wasn't really anything. So as long as, and there was a version of the Little Mermaid that came out like within the last couple years, right? That was a non-Disney version.
Well, like 1991 or 92, there was a Little Mermaid that was not Disney, but was animated.
Oh, really? Interesting.
Yeah.
And so that's ultimately what's going to happen with that's where, I mean, but that's what's ultimately going to happen with Mickey Mouse now, right?
Okay.
Is the character is now in the public domain. But if you make a t-shirt like this and sell it, you're going to get sued and you're going to lose for trademark infringement, not copyright infringement.
Well, just because that the Plain Crazy and Steamboat Willie, the Mickey 1.0, only that is up for public domain. Not like the Mickeys on our shirts right now, with the big white gloves and the smaller tail and
different eyes.
Yeah, and the Mickey that is not so mischievous and Plain Crazy and Steamboat Willie. Mickey Mouse wasn't a likable character. Very, very mischievous.
And I think, and that's what's really interesting. And, for what it's worth, we saw one of the places we saw a lot of litigation about this in the last 15 years is Sherlock Holmes. Because those Sherlock Holmes stories, there was a big body of work, right? That spanned like 25, 30 years that Arthur Conan Doyle wrote. And those stories have been gradually coming into the public domain every year. And one of the things that, the Conan Doyle, I forget what it's called, the Conan Doyle Trust or something like that owns the rights, because he's obviously long dead, right? But there's a legal entity that owns those rights. They would try to sue people, and they would say, you're not using copyright, you're not using public domain elements of Sherlock Holmes. You're using elements of Sherlock Holmes that are still under copyright.
Wow.
And
that's a cluster.
And the thing is, Richard, they lost most of those cases.
Wow.
Because the court would say, so they tried an argument, this was a few years back. They tried an argument of like, well, in the first set of stories, kind of what you were saying, this is why I bring it up, because you mentioned the mischievous thing. Like in the first set of stories, Holmes was kind of a jerk, right? Like he was a jerk, mean to everybody, and he was kind of a narcissist, and he didn't have any really empathy for anybody else. And then, by the later stories, he kind of, he had more feelings, and he was less like Data and Spock, and he had some more emotions, and he had some more empathy for other characters. And so since your Sherlock Holmes has empathy, you are violating the copyrights of those later stories, not the earlier story. Not that you're not drawing from the earlier stories in the public domain. You are violating the copyrights in the later stories. And the court said, no, character development is a thing that fiction does. And you cannot copyright the idea of a character having a character progression over time. Right. And so it's true that is what Conan Doyle chose to do. But any other author might come up with that same idea and write that story. And so Disney's going to run into some trouble probably. Now, these aren't Supreme Court cases. These are lower court cases. But Disney's going to run into some trouble to the extent they try to say things like, like you said, our early version of Mickey was kind of a jerk. He's like twisting them animals into
rubber bands,
something, right? Yeah,
pilot planes. And he was more rat-like than a mouse,
right? And whereas in the later stuff, he's a lot of fun, and so you're infringing our fun Mickey instead of our PETA, violating mean Mickey. And they might try it, but I expect a lot of their lawyers are going to tell them, it, we're going to our only argument is you are writing a Mickey Mouse story in which Mickey's characterization resembles a later work, we're probably going to lose, right?
Oh, big time.
What they could win on is, again, like you said, well, what is the design? The designs are copyrighted. The designs are trademarked. So, for example, with Mickey Mouse, and I don't think anyone's interested in doing this, but with Mickey Mouse, as long as you're writing prose fiction, you're going to win, right? Because if you just write prose fiction about Mickey Mouse, there's no images. So there's nothing, you can't be infringing their designs. You can't be infringing their trademarks. And so if you want to write a novel called, the duck torturer, right? The Mickey Mouse, whatever, they're not gonna be able to sue you for it because there's no trademark issue in play, and they don't own the character as such anymore.
Right. All right. Aaron in the Sky Chat is saying, this is fascinating stuff. Thank you, guys. Well, you're welcome. When I saw all these articles come out in December, it's like, oh, get BG on the line quick. We gotta delve into this, because the more research you do on it, the more confusing it gets.
Oh yeah.
With all these years and all of these asterisks, it gets more and more heavy.
There's a reason lawyers are still able to make lots and lots of money billing their clients, right? No, I mean,
that's true.
You need, whatever, anyone who's thinking about saying, oh, Mickey Mouse is in the public domain, I want to do something with Mickey Mouse. If you don't consult a lawyer, you could, because like you said, you can use Mickey and Minnie, but you can't use Donald and Goofy.
Yeah.
And if you don't realize that, that's going to get you sued right there.
Right.
Or last year, if you released a story with Tigger in it last year, you're going to get sued. Yeah. But now you do it this year, it comes out on January 2nd, 2024, you're good to go. And, it's crazy.
Now,
well, yeah. So I'm wondering, because Disney is still using Mickey Mouse.
It's still active.
Constantly.
It's an active icon.
So should this copyright law even exist if the property is still active? What is the argument for that? Versus properties that aren't active. Who does copyright law help?
So if there's a property that no one is using anymore, there's a Buster Keaton film, The Cameraman, as great as Buster Keaton is in that film, that's who's been talking about that in the last 50 years. So that's inactive. But Disney is still using the old style Mickey Mouse, even in their current logos. So that's still active.
So I think there's a couple layers to it. So one is what I mentioned at the beginning, which is just First Amendment free speech. And anytime we have a law that says one person or entity can stop other people from talking, there's a really heavy thumb on the scale against that. And so we sort of have a bias, just our legal system has this bias against rules that stop other people from doing it, right? So that's the background. That's the deep background. And then part of what you're bringing up, I think, is a change. So I mentioned that first statute in 1710. It comes from the origin of mass publication of books. But I actually, I'll send you guys the links if you want to put them in the show notes. But there's a good article at the Duke Law School. They have a Center for the Public Domain. And one of the things that they have in their article is, so as I mentioned, that under the 1909 Copyright Act, the copyright term was 56 years. And even under the recent studies, they concluded only 2% of copyrighted works still have economic value in their copyright after 55 years. Right? So it's kind of what Richard's saying, at 98%, because copyrighted works is everything, right? Books, comics, movies, sound recordings.
Even everything. Choreography, I learned as I was doing some research.
Choreography. Right. So 98% of that stuff, right? The original owner is not to use the economic word, exploiting
Mm.
that right anymore. No one's going to pay for a license, right, for a 65-year-old poem, right? And so it might as well be in the public domain, right? Because the author wouldn't be able to make any money licensing out uses of their material anyway. What's changed, though, in our economy is very different from 17th century, 18th century, 19th century, and even early 20th century, is these copyrights are now being owned and exploited not by the individual human being authors, but by corporations,
Mhm.
right? Because, I mean, you think about Tolkien, Lord of the Rings, right? Like, his son, Christopher's still alive, right? So you could say, okay, Tolkien wrote these books. They made a lot of money. They licensed movies off of them. J.R.R. Tolkien made a boatload of money when he was alive. Christopher Tolkien gets to make a boatload of money while he's still alive. Hobbit will go into the public domain in 2032.
Oh.
So 9 years away, right, from the Hobbit going into the public domain. Obviously, the trilogy is much further down the line than that. But that's really unusual, right? There aren't that many, especially if we stick to novels, there aren't that many novels that have become popular enough that the original author or their descendants is still going to publishing companies saying, hey, do you want to publish a new edition of the one that came into a couple years ago, The Great Gatsby? Because that's assigned in every school, right? So
Right.
Great Gatsby didn't go into the public domain until 2021. But again, how many, let 2% of books make that. So what's interesting, so the other part of the debate is, especially, and this comes up with the comics, right? The Schuster and Siegel with Superman and Finger on Batman and the guys in Spider-Man and all this
And
stuff,
Shazam,
right?
yeah.
And Shazam it's not these individual human beings that are getting the money, right? They assign their rights to these companies. And so there's a lot of folks who basically say, well, do we think that companies, which can exist forever, right? Human beings eventually die, but companies can exist forever. Do we think that our capitalist economy requires a system in which companies can own copyrights forever? And where it comes up is things like Great Gatsby, the unauthorized sequels, right? Like, while Lucasfilm owns the copyright to Star Wars, nobody could do an unauthorized sequel to Star Wars. But think about all the new stuff we have based on Shakespeare, right? All the new stuff we have based on Jane Austen novels,
Right.
all the stuff we have based on Sherlock Holmes now, right? At some point, Star Wars gets to be that, right? At some point, the Disney catalog gets to be the Shakespeare that people build on. And I mean, Shakespeare's plays predate 1710. So, right. So he never got any money. Right. But it would be a real problem if there was a company like Shakespeare Inc. that still owned the copyright today in Hamlet. Right. And then Disney couldn't make The Lion King because they get sued for copyright infringement by the trademark owner in Hamlet, saying, well, your Lion King story is too similar to Hamlet. And right. And so that's the debate. Like, at some point, doesn't Lucasfilm or Disney or DC Comics, right? I mean, Superman's sometime in the 30s, right? 1930s? Isn't it?
Yeah.
Right? So 95 years, right? So sometime in the next 10 years ish, Superman's going to go into the public domain, right?
Well, funny you should say that, because some of the old Superman comic strips were not copywritten.
Oh.
So when DC tried to sue Fawcett Comics over Shazam, wait a minute, Shazam, Superman, it's the same person in a different costume. Well, the judge overruled the initial decision and said, wait a minute, there's a couple of Superman comics that weren't copywritten, so we're going to place the winning judgment over to Fawcett Comics, and they can now do Shazam.
And
because they let him slip.
You mentioned that earlier with Peter Pan, because that came up in the public domain article I read too. The book version of Peter Pan, they botched the copyright issue, like Richard was talking about. So the book version of Peter Pan went into the public domain in 1967.
Oh,
But the stage play, didn't go into the public domain until this year.
wow.
Right. So again, different versions. And that was a function of just the lawyers messed it up, right, at the time.
Right, yeah.
And
Not
so
thinking about what the ramifications and who it can now grab these characters and do what with them.
Right.
Back then, as far as I know, there wasn't an internet, right? Back in 1911?
yeah.
No?
No.
No.
Okay.
I
So,
think pretty sure.
yeah, no VHSs, no streaming, no nothing. So, who's going to take what?
Hmm. Well, go ahead.
Oh, I was going to say, before we did all this research on this, I thought the copyright law was a bunch of hogwash. You know what? If you own the copyright, you own the copyright. But like BJ, as you were just saying, if these don't go into public domain, we're never going to see the light of day of the fall of the House of Usher, which was a whole series based on the Edgar Allan Poe short stories and poems. And because of the fall of the House of Usher, we went back and looked at some of those old Edgar Allan Poe stories. And so it just reinvigorates the brand and retelling. Now we know who Edgar Allan Poe is because of all these modern retellings. So that's a big pro for all this.
Yeah, and the copyright expiration really helps us have access to these cultural materials that might otherwise be lost to history.
And they would be lost to history.
Yeah.
And actually, one thing that's really interesting about it too, that the Duke website brings up, is there's actually a lot of old films that have been lost.
Ooh.
Because they it was in a warehouse, right? They had film, old
on
film,
nitrate,
right? Yeah, in a reel, in a canister, on a warehouse. But they didn't know who owned it, who, if anyone, owned the copyright anymore. And the kind of work that you would have to do to restore it is copyright infringement, right? Like it's going in and changing, and you're making what we call a derivative work, right? You're basically, it's thinking like a painting restoration, right? Like it's not actually technically the original painting. It's a new version of the old painting. And so there's these films that have basically the viewpoint of the public domain scholars is there's these films that ended up being lost to history because the film preservationists were too scared by copyright law to do the restoration work that could have saved these films. Right. And that's a tragedy, right? That's a tragedy to think that sound recordings and films didn't get preserved because somebody's worried, if I preserve this film and then some copyright owner comes out of the woodwork and sues me for it.
Wow.
Right.
I mean, and so, there really is this sort of notion of that copyright can have these unintended consequences. And one of the things, and there's not to get in the weeds of it, but that's what we call orphan works, right? It doesn't have anything to do with Disney, right? A big company like Disney is never going to lose. We're never going to lose track of who owns the copyright in anything that Disney has copyright in, right?
Right.
No.
But if you imagine you go to a garage sale or an estate sale, and you find some home movie reels or something, and you're like, this looks really cool, I should digitize this and put it on the internet. Well, it's got a 95-year copyright in it, right?
Yeah.
And if you don't know who's the family in these home videos, and there's this, I mean, I don't know, some of the times it's tricky. It's like, what are their damages, right? Necessarily. But if you found some home videos from the 70s and you digitize them and you put them up on YouTube and they went viral and you got a bunch of monetized clicks on your YouTube video, and then that the little kid, 5-year-old kid in that video sees it, that's me, sues you, he's going to get all your revenue from that work, right? From your monetized YouTube, plus damages on top of that. So you're sitting there saying, this is cool. Like, why, we should preserve this. This should be digitized. This could be shared. This is fun. It's like, it's America's Home Videos from the 70s, right? Like it should be, but you couldn't risk it. And so that's, again, part of this idea. Well, shouldn't there be a way where you could say, if I have this work and I'm not able to determine who the owner is, shouldn't there be some way that I could then say, well, I'm going to post some sort of notice with the Copyright Office that I'm intending to exploit this work or something like that, right? And then if nobody shows up and claims it, then you get to use it, right? I mean,
Yeah,
there's,
it's
there's
lost and
no
found. If no one comes to pick it up, it belongs to whoever.
right,
You got
exactly,
in the office.
exactly. So I mean, there's you know, there's history, there's cultural history that copyright, you know, in a weird way, maybe makes it harder to preserve it instead of easier. So it's there's that's why it's so complicated, right? Like if there were easy answers on this stuff,
Yeah.
lawyers wouldn't make any money at it, and Congress would know what to do, and we'd have really clear laws.
Yeah. Well, and another downside is these old films on nitrate. You even say the word fire, they're going to combust. So there should be a way to preserve them and then have that notice in the Copyright Office saying, hey, within 5 years, if no one claims it, guess what? It becomes ours.
Yeah. I want to bring up like a story where, you know, we're a good example of work that has entered public domain and then it was basically saved from obscurity because it got used again. So this would actually be the Nutcracker story. So in 1816, E.T.A. Hoffman published a story for adults called The Nutcracker and the Mouse King. And it was a little more geared for adults, but in 1844, so how many years later is that? Do the math.
30 something, right?
30, yeah, something like that, like 31 years or something.
28.
28 years. There you go. The story was then modified to a child-friendly version by Alexandre Dumas. And so 1844. So then in 1892, the chief ballet master of the Russian Imperial Ballet, Marius Petipa, he commissioned Tchaikovsky to compose the music for his 2-act ballet. So in 1892, that's where you get Tchaikovsky's Nutcracker, which famously he did not like this ballet. Like he wrote it and it was like one of his least favorite works. I don't know why.
We're all our worst critics.
Yeah, exactly. So then the Nutcracker, the ballet kind of languished. The music was still around, and so 1940, Fantasia comes out, Disney's Fantasia, and Tchaikovsky's Nutcracker Suite is in the public domain at this point. So Fantasia uses the Nutcracker music for that famous fairies changing season sequence, and it's beautiful. But the ballet at this point was not being performed at all anywhere. However, then you go to 1954, and George Balanchine founded the New York City Ballet, and he choreographed his own version of the Nutcracker Ballet, having done his homework and knowing that the Russian Imperial Ballet had done a Nutcracker version ballet. And he was actually Russian. George Balanchine was a Russian immigrant who founded the New York City Ballet. So he choreographed his own version and was eventually able to copyright his choreography of that ballet. And so now that's when the ballet became famous and is used all over the world pretty much annually. And anyone who uses his choreography, he gets the money for that.
Royalties.
Yeah, from royalties. Yeah, it's very interesting. And now it's this annual production. Now you can't go to a major city without seeing Nutcracker Ballet at Christmas time. Yeah. And it's this huge thing because it found its way from copyright expiring to copyright expiring to copyright expiring to be this big thing.
And it's great that you mentioned that, Sarah, because that's one of the interesting things about the interaction between copyright and public domain, right? Which is, so you say you go any downtown at Christmas time, anybody can play the music.
Yes.
Because the music is in public domain.
Yes.
Right? But that doesn't mean you can put the clip for Fantasia on YouTube. Because you can put the music, you can record your own version of the music and post it on YouTube because it's in public domain.
Right.
But if you post a clip of the animation from Fantasia, Disney can sue you for copyright infringement because they don't own the music, but they own the animation.
Right.
And then, but their animation doesn't use George Balanchine. Well, that's actually probably before Balanchine, I guess. In the time.
Yes, it is.
But I mean, even so, they weren't using his choreography. Right. In their animation, they're doing something different. And he's not using their choreography of their dancing things in Fantasia in his ballet. And so now you have this, it was like in 2024, anybody can do the music. Only Disney can play their animation. You have to pay royalties if you want to dance that specific choreography. But if you want to choreograph your own new choreography for a new version of the Nutcracker, you're good to go.
Yeah, so there's a ton of pros I see with
Yeah.
this, where this whole conversation really turned the tide for me.
Mm-hmm.
Until you
Oh.
get people who want to abuse it, take advantage of it, make a quick buck. And I'm talking about these horror films. Now in 2022, when Winnie the Pooh, when that copyright ended, and suddenly we got Winnie the Pooh, Blood and Honey. Now everyone associates Winnie the Pooh with Disney. So
Yeah.
Disney was all up in arms about this, even though Disney doesn't own the rights to Winnie the Pooh. And yeah, that's
Didn't they?
Milne. He owns the right. But if you want to see Winnie the Pooh in the big red shirt with a honey pot on his head, that's Disney.
Mm.
And we saw this film Blood and Honey. So any kid watching that trailer somehow got on the internet. Kids can do more things on the internet than all three of us combined.
I'm sure the trailer's on TikTok.
Yeah, exactly. then they see this new movie, Mickey Mouse Trap, where a guy in a Mickey Mouse Steamboat Willie mask is killing kids at an amusement park. That trailer is all over the place. And now there's a new Steamboat Willie horror film coming down the pike where a mass murder on a big steamboat killing kids
Oh my gosh.
in a Steamboat Willie mask. Now, of course, they're like, these people have been waiting and waiting for this moment. But I think that is extremely irresponsible, taking characters that are for kids. And kids will see this because, an older brother and sister will be like, hey, come on over here. I want to show you a new Mickey Mouse cartoon.
Oh.
And you know that's going to happen. And kids are going to be terrified of Mickey and Minnie and Winnie the Pooh. I think that's extremely irresponsible.
Mm.
And as you sort of have mentioned, I mean, we've been talking about, too, is Disney can't do much if the design is different enough that it doesn't conflict with their trademarked designs. And especially with some of these horror movies, you've got these, it's quite clear it's not a Disney production.
Yeah, no one's going
right?
to confuse it. No
one's going to confuse it. And so you don't have you don't have a trademark problem. They don't own the copyright, so they can't stop anybody from writing any story they want about, Winnie the Pooh and Mickey Mouse are just like Snow White or Robin Hood, right? You try to make Robin Hood a red fox, you're going to get sued, right? Like Sarah, like your Run Disney, Run Disney outfit, right? If you try to do that Robin Hood, you're going to get sued. But I mean, we had Men in Tights, and we had the Kevin Costner version that was a little more serious, Prince of Thieves, right? So, and we had a Robin Hood in the ABC show they did.
Oh, Once Upon a Time.
That's
Once Upon a Time, right? They had a Robin Hood
Yeah.
in there that was different. So, that's where, anyway. So I, what's interesting is I think it's two things, right? One is the shock value is going to wear off pretty quick, right? Because they're doing it for shock value. They're spending a lot of money to do it for the shock value, right? So now maybe, look, if maybe they were just doing trailers and they didn't actually make the movie, they just like made a fake trailer for a fake movie just to have Slasher Mickey.
Yeah.
Then that doesn't cost you very much money. But at a certain point, these guys are going to stop making real movies based on these characters. Like how much are you spending to make this? Like how much it's going to make at the box office, right? Like how much did Blood and Honey make at the box office?
4.9 million worldwide.
Wow.
Right? So, which is probably more than they spent to make it. So,
right,
I guess But at a certain point, right? Like how many $5 million movies are we going to make before the chuckles wear off? Right?
Right.
So I think that's part of it. And then the other part of it is, even while things are under copyright, our fair use doctrines create a lot of wiggle room for satire and parody, even for profit. And so now, again, people typically don't take their chances with the Walt Disney Company because just like just like you don't mess with Apple and Amazon, right? Like you don't.
Right.
Yeah, they get helicopters coming by and dropping lawyers with parachutes.
There's several examples. I won't mention the lyrics because we're on a family-friendly show. But there was the Roy Orbison classic "Pretty Woman," right? And then in the '90s, Two Live Crew, did a remix called Pretty Woman that was graphic and profane and sexualized and sampled, as we say, sampled the Roy Orbison, not just the lyrics, but the sound recording, the actual sound recording. And so the Orbison estate sued, and it went all the way to the U.S. Supreme Court, and they lost.
Wow.
Because
Orbison lost.
Orbison lost because the Supreme Court said this use, now there was little clips, right? So, but this minimal use of the copyrighted work for the purpose of commenting on it, satirizing it, critiquing it is fair use.
Wow.
And right. And so now again, I think it's, I mean, the horror movie version is debatable, right? But I think you have an interesting problem of even something that's under copyright. If what you're doing is making a, so we say, unauthorized sequel, right? An unauthorized derivative work, that is, mocking it, satirizing it, making fun of it. I mean, for what it's worth, Weird Al Yankovic gets licenses for all his stuff, right? Because he doesn't want the fight.
He doesn't mess around.
And if somebody says that if they deny him the license, then he just doesn't parody their song.
Right.
But he's actually got a pretty legitimate argument that he doesn't need licenses for those parodies.
Well, there was that one rapper whose name I forget, who said you can't use it, and he went ahead and did it. And the rapper said, "If I ever see you, it's gonna be trouble."
Right. It's not legal trouble. It's the guys with the helicopters again.
Yeah.
But anyway, so I think, that's again where it's tricky. The last thing I was going to say about that is trademark law has this other really interesting angle to it that doesn't come up very much. But because as we've been saying, most of what trademark law is about is confusion. But there's a special rule that came into enactment in the 1990s. And you have to be what's called a famous mark. And it's a technical definition under the trademark law. But if you're a famous mark, you don't get just confusion protection. You get what's called anti-dilution protection. You actually do get protection against uses that tarnish or dilute the value of your mark. Now, again, and so Disney hasn't really had to litigate this much with Mickey Mouse yet because people are scared enough of Disney as it is to not try to do it. But I think because of how much they use Mickey in particular as an icon of their parks, and he's in front of the animation, right, and things like that, I'm sure they will try to say that Mickey Mouse is a famous mark. And that might then allow them to say, even if your use of Mickey is not confusing, it's tarnishing our mark, and we can sue you. We can stop you. We can get an injunction to stop you from doing it. So that I'm sure somebody at some point will get sued for that. And we'll see, there'll be a whole cascade of decisions that would have to get made about whether Disney wins or loses it. But they'll try for sure.
That makes a lot of sense, honestly.
Oh, yeah. By the way, that rapper was Coolio.
Oh, okay.
Yeah.
Huh.
Because I think of that with like the Star Wars logo, right? Star Wars, the words, what I'm talking about, like with the special script and star on top of wars, stuff like that. That's, I'm sure, a famous mark.
Yes.
Oh, very much so.
So if you tried to, so they could stop people from maybe parodying or satirizing that logo because it's so famous. Whereas, if you want to make, they have a trademark in names like Darth Vader and Luke Skywalker, those are probably just ordinary trademarks, and you could probably get away with tarnishing those. But
speaking of that, the filmmaker who did Winnie the Pooh, Blood and Honey, someone had asked him, "Are you going to do a Mickey Mouse horror film?" This guy was smart enough to say, "No, I'm not that stupid. I'm not going to get that close." But let's say a couple of years ago, someone wanted to make the Steamboat Willie horror film. Can't they say, "Well, it was a parody horror film because Mickey Mouse is not that likable of a character in Steamboat Willie. So can they say, well, it was a parody and get away with that?
They could, well, see, this is the beauty for lawyers of this law. Because what I was about to say is you could try, but you couldn't be sure you'd get away with it, right?
Right.
Because
Yeah.
of the way the law is structured and the way fair use principles are structured. Now, look, I have to say, if you did it, you filmed it, you made clear it wasn't sponsored by Disney, and you posted it for free on YouTube, you'd have a stronger argument, right?
Mm.
But if you're releasing it in theaters and going to make $5 million and you're doing it commercially, that was why the True Life Crew case was complicated, because they were clearly making a lot of money off their song,
Right.
as well. But you come to a lawyer and you say, I want to do my, whatever, I want to do my, werewolf Goofy. Goofy's a werewolf and he's out there, killing killer dog Cujo, my Cujo Goofy movie, right? Where Goofy's out there killing people. Because he's still under copyright today, right? But it's going to be a parody. And so Disney pretends they're the happy place, but really they're, horrible.
The horror place.
Yeah, right. Can I do, if I make this movie, are they going to be able to successfully sue me either for an injunction to stop me from releasing it or for money damages, afterwards? And the lawyer's going to say, I don't know. Right? The lawyer's going to say, well, let's talk about it. Show me what you have in mind. And a lawyer might be able to say, look, given the materials you showed me, you have a 66-33% chance of winning, right?
Right.
Or you have a 75-25 chance of winning. Or Disney has a 75-25 chance of winning, right? But no smart copyright lawyer is going to look at a scenario like that and say, I can tell you 100% sure you're in the clear.
Oh, yeah.
Right? And so at that point, it then becomes this person who's planning to do this. How much money and time are you going to put into something that
it's a huge risk and gamble?
It's a huge gamble. It's a huge gamble. And most people aren't going to want to roll those dice.
Well,
especially against Disney.
Right.
Yeah, understandably. And you can't say, oh, Disney, you're this mouse, you're the house of horror because you're suing people. Like, yes, we invested a lot of money and time into our property for us, for others to enjoy, not for others just to take. So it's the bigger you are of a company or of a person, the more evil you are. Like Aaron in the Sky Chat is bringing up the fact that Disney was trying to sue a daycare for a Disney mural they had painted on a wall. It's like, well, you know what? But daycare, you don't own that property, so you can't just put it up on there. Now, I know that's an extreme case, and Disney got on other daycares for charging to show Cinderella for like a fundraiser.
Interesting.
So that's how people are saying that. Oh yeah, you're only in it for a buck. They're a company. Yes, that's what companies do. They want to make a buck.
Yeah, they do have to pay the people who run the company. And
we're shareholders in Disney, and yes, we don't want anyone stealing from us.
Yeah.
But Richard, you mentioned something earlier that's so important with this too, right? Which is they tend to care the most when what you're doing with their copyrighted material is something they would get to sell you otherwise. Right. So if you could go to Disney and say, I want to have a Disney mural on the wall of my elementary school or my wall of my daycare. How much do I have to pay you for the license?
Right.
And they would send a lawyer over and you'd work out a contract and you'd have to have the trademark logo on the wall and everything else. Right. Or theatrical exhibition. I mean, I know it doesn't feel like it, but like come to the gym and we're all going to watch Moana together to raise money for the band trip to the parade, to the Rose Parade. But Disney charges money to come see Moana. Right. Whereas something like you write your fan fiction, you publish it on Archive of Our Own, that's not really competing with the small amount of publishing that Disney does officially.
Yeah.
And no one's and no one's making money on it. Like, you're actually losing money on it, right? Because you spent time and effort writing this fan fiction, which is time is money, right? So you actually you spent opportunity cost of money to make this. You're not getting anything back in return. And it's free advertising. You know, the fanfics, the fan films, the fan art that's all over social media. Trying to sue the nonprofit, just, hey, look at this drawing of Ahsoka that I did. I was so inspired by the finale. I did this art of Ahsoka looking at Force Ghost Anakin or something, right? Sorry, spoiler for those who haven't watched, right? Like, it would be bad publicity for them to sue that person and say, you can't post that on Facebook. That's right.
Right.
So,
exactly.
so as long as it's not competing with a way that the company would make money,
Right.
it's free publicity, and they're going to go look the other way. But anytime it's something that they would rather, like t-shirts, art, you know, exhibition of the property, then they almost have to sue, because otherwise they're kind of making it look like they're not keeping a tight control over their set of rights that come with their copyright.
And they're getting away with it, then they're going to do it, and they're going to do it, and they're going to do it. But as an asterisk, Disney did back down from those daycares.
Oh.
Because they were getting a lot of really bad flack.
Interesting.
Yeah. Yeah. Well, this has been very, very informative there, BJ.
Yeah.
Well, I'm glad thank you.
Of all the research we've done before this, now I feel even better going forward. And knowing that public domain isn't the evil I once thought it was. It's protecting art, and 99.9% of art will have been lost if it's not being protected by public domain. Just stop making horror films around Disney characters, okay? It's not that hard. Stop doing it.
Yeah, let your creativity flourish in other ways.
Yes, it's a quick cash grab. Yeah, all right, get it out of your system. But after 2024, all right, no more of that. Okay, we're done with it. All right, hold on. There's a comment here in the Sky Chat from Aaron. Invite more lawyers on your show.
Yes. And also,
well, as a lawyer, I'm professionally obligated to say I agree with Aaron. You should have more lawyers.
I also want to bring up Justin's comment, who says that he had never heard about Blood and Honey unless it's geeky people talking about copyright.
Yeah. Hey, Justin. I thought we were friends. All right. So, BJ, if anyone wants to contact you and learn more about law, or just say hi, or we agree and thanks for informing us, or to talk about hyperspace theories, where do they go?
So you can find me most easily at Fangirl Blog. It's fangirlblog.com. I blog there. Hyperspace Theories podcast is hosted there. We have episodes, not quite every month, but we try to have episodes. I host that podcast with Trisha Barr, who is Sarah Woloski's co-host on Fangirls Going Rogue. So you can find me there. I'm also on social media, not super regularly, but you can find all that information at Fangirl Blog. So yeah, it was great to be on the show. I'm glad we had a good conversation.
Well, it says here online on IMDb, Winnie the Pooh, Blood and Honey was directed by BJ Priester. BJ! Would that be funny?
That would be crazy.
You know, Richard, if I had $5 million that I had made from my Blood and Honey movie, I would have a much more entertaining life right now than no, I love my job. I have a great job, but I do not make $5 million a year as a law professor. So maybe I should start making cheesy horror movies. I don't know. Maybe I'm in the wrong profession.
Look what we've done. No, BJ, okay, get him out of here. Get him out of here. All right.
I also want to say Aaron's trying to copyright his snark.
Can you copyright snark? I don't know. All right, awesome. So we're gonna end this stream now. Yes. So everyone who joined in, thanks very much. Yeah. Thanks for commenting.
And BJ, stay on for a minute.
Yeah, we have some words for you, BJ.
Yeah. All right, bye everybody.
BJ, Blood and Honey.